to our Managing Grievances for Effective Outcomes webinar that's been facilitated by HR Recruit and Nathan Adams. My name's Jo Thompson and I'm a consultant for HR Recruit. I'm joined today by Nathan, who will introduce himself shortly. Nathan will draw on his professional experiences handling complex grievances to share tips and best practice in handling the grievance procedure. If you've got any burning questions during the session, please put them into the chat box facility and we'll cover them at the end. I'm now going to hand you over to Nathan, who will introduce himself and start the event. Thank you.
Thank you, Jo. Good afternoon, everyone. It's nice to be here with you over the next hour. I'm sure some of you will have attended previous sessions I've run before, so if there are familiar faces on the webinar, it's nice to be with you again. I'm just going to give you a run through for those who haven't attended a session with me before, just a bit of information about me and my background. So I work for Fretton's Solicitors. My name is Nathan Andrews. I'm the head of HR services at Fretton's. I'm a senior HR case manager, so I do a lot of my work in terms of the HR spaces around employee relations management. I'm a trained and qualified investigator. I'm also a CRPD level 7 qualified practitioner. And I've spent about 22 years in professional practice. As I say, all of my work is focused on employee relations. So over that time, my in-house kind of corporate roles were handling ER cases, and then my consultancy background, which spans over the last 10 years, has again been providing ER case management support to client organisations across many different sectors. So I'll be drawing on my experiences over the last 22 years in terms of how I approach and manage and handle grievance processes. So just to give you a breakdown of what we're going to discuss or cover today. So the objectives of our webinar today is to talk about what grievances are, the ACAS Code, how to respond when you receive a grievance, the investigation process that you should conduct when you are handling grievance matters, conducting a grievance meeting. We'll touch on the right to be accompanied, and then we'll talk about the outcome of the grievance process as a whole. I appreciate some of you on the call will be HR practitioners, so this might just be a refresh for you. There may be some people in line management roles who are new to line managing employees and may have not dealt with grievances before. So I'm hoping this session will be informative and give you some hints and tips for you to take away with you. Just to point out, everything I discussed today should not be considered as specific legal advice or HR advice. Obviously, if you have ongoing live matters within your organisation, you should absolutely take specific advice regarding the specific matter that you're dealing with. If you are in need of advice, then that's something we can support you with. But I just want to be clear on that point. Nothing that we discussed today should be considered specific legal advice in relation to any matters that you're currently working on. So I want to start with what are grievances, and this is often a question I get asked when I'm supporting line managers in smaller organisations. So for the majority of us who are working in the HR space, will know that grievances are largely concerns, problems or complaints that employees may have in relation to their employment, and they may raise those concerns with you as their employer. They may raise those concerns on an informal basis, or they may raise it more formally in writing with you. But typically grievances are around concerns or problems that employees have directly in relation to their employment. Grievances can concern an employee's role. It could be about their working environment. It could be in relation to pay and benefits, or it could be concerning working relationships that those individuals have with their work colleagues. This could also extend to issues outside of the employer's control. So, for example, it could be an employee might complain about a working relationship they have specifically with a client. I've dealt with situations like that before. So again, it's just to kind of put this into context for people who are maybe not used to dealing with grievances in practice. So grievances can help an organisation to uncover unacceptable or even unlawful practices that could have an implication for the organisation and its effectiveness in relation to its operations. But it could also be that you're dealing with matters that, if they're left unresolved, it could potentially damage your reputation as an employer. So it's in an employer's interest to enable staff members to raise grievances without fear of repercussions. That speaks a lot to culture, and creating a culture where people are not fearful of speaking up when there are issues, and also creating a culture where employees understand that if they raise genuine concerns in line with the grievance procedure, that those issues will be dealt with properly. The ideal situation is to create a culture, obviously, where employees can raise issues on an ongoing basis with their line managers when the issues are maybe minor or smaller in nature, and therefore an informal approach can often be sufficient to resolve those issues. So I always say to client organisations, it's really helpful when you're talking about culture to build in a culture whereby open communication is encouraged and it's well established, and that people can raise small issues as and when they may occur, and they can be resolved informally without the need to go through a formal grievance procedure. That being said, if an employee raises serious issues or serious concerns about their employment, you absolutely want that employee to feel confident in being able to raise concerns, more serious concerns, on a more formal footing in line with the grievance procedure if it's considered that is necessary. If you are following an ACAS code on disciplinary grievance procedures, there is an expectation on an employee to put their grievance in writing. However, the one thing I often say to clients when I'm working with clients and we're handling grievance issues is that they should be aware of issues that don't necessarily fit into a neat box, such as a letter with a subject line formal grievance. I've dealt with issues recently whereby an employee's raised, an email, they sent an email to their line manager, they've raised concerns, they've not formally labelled that email as this is a grievance, but actually when you read it and you take a step back, it's obvious that the employee has complaints, and actually when you read between the lines, those complaints could potentially be serious. So what I always say is, don't wait for an employee to submit an email or a letter or to speak to you to say, I'm raising a formal grievance. If somebody submits something in writing or they speak to you and they're raising concerns, you need to take a step back and consider the nature of the concerns being raised. Are those concerns sufficiently serious enough that we might need to investigate, for example, or are they actually being raised at an early stage where an informal approach could be deployed to resolve those matters and bring them to resolution? So that's an important point to consider. Another point I always say is that we need to remember that an employer's obligation to resolve and deal with the grievance does not require you to resolve or deal with the matter to the employee's satisfaction. So sometimes I'll deal with clients who often feel a sense of pressure that they must resolve the employee's complaints to the satisfaction of the employee. But actually what we always say is that all that is required is for the grievance to be resolved or dealt with fairly and reasonably in all of the circumstances. And it may be, and I've dealt with many grievances whereby we've investigated, at the conclusion of the investigation, there's actually insufficient evidence to support that there is a case to answer, or that a case should be referred to a disciplinary hearing. And that's something we then address and deal with at the grievance hearing, when we set out our findings to the employee and ask for them to comment on those findings. So, I want to reiterate that, your obligation as an employer isn't to find solely in favour of the employee, it's to deal with complaints consistently, fairly and reasonably in all of the circumstances. So that's an important point to remember. A common question I often get asked when dealing with clients who receive complaints or grievances is they say, do I have to deal with this? Can we essentially, just ignore it? And actually, as we all will know, good practice is, yes, you should absolutely deal with complaints as and when they arise. You shouldn't ignore them. If a matter is left unresolved or ignored, the likelihood is it will fester and become more serious in nature. There are obviously legal risks in ignoring a grievance, and so we need to be aware of those legal risks. Those risks include the employee resigning and making a claim for constructive dismissal, suggesting that actually an employer's inaction to address their concerns meaningfully and proactively could cause a loss of trust and confidence which should underpin the employment relationship. We want to avoid being in that position. So ultimately, we shouldn't ignore a grievance. We should deal with it proactively and without unnecessary delay. If your grievance procedure is contractual, and I must be clear, I always advise that a grievance procedure, along with a disciplinary procedure, shouldn't be contractual because it does restrict you. But if you are an organisation that does have a legacy grievance procedure and that is contractual in nature, then you need to make sure you follow that procedure to the letter. Otherwise, you could be dealing with a claim for a breach of contract. An employee could also claim that if you ignore their grievance on the grounds of discrimination or whistleblowing issues or some other protected characteristic, that could give rise to potential claims that you then need to address and look to defend. So it's always best to deal with the grievance proactively, go away, investigate the concerns being raised, and follow the process through to conclusion in line with your grievance procedure. So it's a really important point to consider. So I just want to touch on the ACAS code. Most of us who are operating in the HR space, or indeed if you're an experienced line manager, you will be very familiar with the ACAS code and disciplinary grievance procedures. So the ACAS Code of Practice is a statutory code approved by Parliament. Failing to follow the Code of Practice does not necessarily mean you've acted unlawfully in and of itself. However, you should find, if you find yourself in the employment tribunal, they will take into consideration any lack of adherence to that code of practice. That's a really important point to consider. So failure to follow the code of practice on disciplinary grievance procedures could result in the employment tribunal increasing any compensation award by up to 25%. So that is an important point to consider if you are an employer. Failure by an employee to follow the guidance set out in the code could also result in the employment tribunal decreasing any compensation awarded by up to 25%. So that again is another point to consider, but the point we should focus on is our obligations to make sure that we follow that code of practice, so that if we do find ourselves in an employment tribunal having to defend a claim, that we don't have to face an increase in any compensation awarded for not doing so. It's a really important point to remember. So again, still talking about the ACAS code, but general principles. So an employee should let you know as an employer the nature of their grievance. They should, the employer or you as employers should hold a meeting with the employee to discuss the grievance, and you should go into some detail of this, but particularly if the grievance raised is complex in nature or there are multifaceted elements to that grievance. So it's always, it's really important you hold a meeting and discuss the grievance in detail. You should also allow the employee to be accompanied at the meeting. You should investigate the complaints thoroughly. That's really important. We'll talk a little bit about the investigation process and setting out a plan for the investigation shortly. You should decide on an appropriate action following the investigation. So, for example, if you investigate and you believe there is a case to answer and therefore the employee's grievances are upheld, it may be that matters need to be referred to a disciplinary hearing in relation to the respondent in the matter. So that's another important point to consider. An employer should allow the employee the right of appeal if they are dissatisfied with the outcome of their grievance. Again, that ensures that you're remaining compliant with the ACAS code. So that is very important as well, and an important point to remember. I will just add at this point now, I have come across several times recently whereby a client organisation has drafted a grievance outcome letter and have inadvertently forgotten to set out the employee's right of appeal in the outcome letter, albeit the right of appeal is stated in the procedure itself. Those employees in these particular cases, I'm thinking of two that I've dealt with recently, they then have realised that actually their right of appeal was denied because it wasn't included in the outcome letter. So it's really important when you're drafting an outcome letter to make sure you have a checklist, and that checklist including the right of appeal and the timelines around that right of appeal. Typically, I see is in policies that our clients have in place, it's typically 5 days from the date of the grievance outcome letter. But it's really important when you're structuring your grievance outcome letter that you do include that at the end. So I want to talk about responding to a grievance when you receive one. So the ACAS code on discipline and grievance procedures states that if it's not possible to resolve a grievance informally, and that's always the preferable position, right? If we have a grievance and we believe we can deal with things on a more informal level, then that should be the goal. So I always say if you can deal with something formally, absolutely. However, if the matter is more serious and you feel that it can't be dealt with informally, then you should deal with matters formally and without unreasonable delay, and that should be dealt with by a manager who is not the subject of the grievance itself. And this should be done in writing, and it should set out the nature of the employee's grievance. So it's really important that we do respond proactively. Sometimes I do see when I'm supporting clients that there can be a delay in responding to an employee's grievance. Sometimes that can be attributed to, an employee submitting maybe an extended, complaint letter, and it's got multiple issues, and so it can feel complex for the line manager to deal with. But what I always say is, if you are an organisation with in-house HR, speak to your HR team without delay. They will support you and they will guide you through the process. So, just as a recap, ideally, a formal grievance should be raised in writing. Don't get hung up on that though. You can always ask the employee to submit the nature of the complaints in writing later if they raise concerns initially with you verbally. And obviously, if they are meeting with you to raise concerns verbally, you can take notes. I suggest those notes are as detailed as possible, and that you then give a copy of those notes to the employee and ask them to confirm that they are in agreement with the point you've captured, and that the notes essentially detail the full extent of their complaints. But ideally, if an employee can put it in writing, that then forms the framework of your investigation. Additionally, there is no value in arguing employees not raised a formal grievance because they didn't label their complaint as such. So if they've submitted an email and they've not specifically labelled it as a grievance, I would always say apply a common sense check on this particular point. If it's going to be obvious if an employee is raising complaints or grievances, and it's going to be obvious whether they're serious in nature or more minor, and can be therefore dealt with informally. So it's always worth just adopting a common sense approach on this particular point. It is always helpful to ask an employee to put their grievance in writing in their own words, and I think that's helpful because it provides a written record of the complaints directly from the employee rather than a summary, from us if we're dealing with it verbally. The employee can build in structure to their complaints or their thinking, and also the points they wish to make and the points they wish you to go away and investigate potentially. It also helps to make sure that they capture everything they want to table. I always say when an employee submits a grievance in writing, I will say to the employee, does this contain all of the issues you want me to consider? If there are any other points you need to raise them now, because I don't allow an employee to do is to raise further issues after the event. We need to be able to understand what the issues are, decide whether we need to deal with it informally or formally. If it's going to be dealt with formally, we need to investigate, and we then need to build in a structure and a plan around the investigation so that we can manage the grievance process that we follow. So again, still on how to respond. So when receiving a grievance from an employee, you will need to appoint a person to handle the grievance procedure. The person responsible for handling the grievance process is usually the line manager, unless they are the subject of the grievance. The grievance officer can also be someone senior to the complainant's line manager. So, for example, it could be the line manager's line manager, and that's normal. I see that often in my professional practice. They should not be the most senior person in the organisation, however, as you will need to keep someone available to hear any appeal should the employee be dissatisfied with the outcome of their grievance. If the grievance concerns a director or someone in the HR department, then you should consider appointing someone external to the business to handle the grievance process so that you can demonstrate you've taken steps to conduct the process independently and impartially. You should hold an investigation meeting with the employee raising the grievance to gather facts and be clear on the nature of the complaints being made. In addition to holding an initial investigation meeting with the complainant, you should write to them confirming receipt of their grievance and set out what will happen next, because you want to manage the complainant's expectations around the grievance process and what you will follow. In your letter, you should include a summary of what you discussed during your initial investigation meeting with the complainant. You should provide them with a timeline concerning what will happen next and when you anticipate being able to hold a formal grievance meeting with the complainant. And you should be clear, you shouldn't be vague, and you should always honour what you say you're going to do and when you say you're going to do it. Sometimes timelines can change due to there being delays in being able to speak to witnesses, for example, if witness availability is impacted by holidays or sickness absence. So if there is going to be a change in the timeline you've originally set out to the individual, you need to go away and update them, keep them informed, so that actually what happens is you build a good rapport with the complainant and they can see that you're dealing with their grievance proactively and you're dealing with things openly and consistently. Keep the complainant informed of progress, especially where matters are complex. I deal with grievances sometimes where we get, a 10 to 15 page grievance letter and we set out an initial investigation plan and the matters become more complicated as we start to investigate and start to fact find. And so if the matter is going to become more elongated because of the complexity of the issues at hand, just again, update the individual complainant so they're fully aware. So the investigation itself, what do you need to do next? So I always say identify the issues in the grievance and list them all in a summative format, so you can refer to this later. What I do when I receive a grievance letter, and as I say, sometimes I can receive very lengthy grievance letters, is I go through in detail, I highlight and pull out the specific allegations or points of complaint, and I list them in a bulleted format so that I can clearly see what the allegations are, and I use that then as the framework for my investigation. For each issue, think about who might have further information. So you set, what you want to do early on is identify the witnesses you may need to speak to. And then you need to think about, is there any documents that you will need to review as part of your investigation? If so, list them out and kind of set them out against each issue. Because again, that forms the framework that you're going to follow as part of your investigation. So I always recommend, and anybody that's joined my sessions before will know, I do a lot of my work is focused on conducting complex investigations, both relating to disciplinary matters and to issues around grievances. It's really important to formulate early on a detailed investigation plan. I cannot stress that enough. That investigation plan becomes the framework that you will follow and it will govern your overall investigation into an employee's grievance. An investigation plan will help to focus the minds of not only the investigator, but those of the people commissioning the investigation. So for me, while I'm working in a consultative format, what I like to do is set out the investigation plan with my clients so they can clearly see the steps I'm going to take and where I'm going to be spending my time. So a good investigation plan should set out who the investigating officer will be, the terms of reference of the investigation, a provisional timeline, because the timeline may change, identification of the relevant company policies and procedures which apply to the matter under investigation, issues which need to be dealt with, the types of evidence which need to be collected, so that might be witness statements, CCTV footage, copies of documentation such as policies and procedures, it could be even IT access logs. You'll also need to think about the people who need to be interviewed, the specific arrangements for investigation meetings, and the date the investigation should be completed. It's particularly important to have a provisional end date in mind and to almost build out a project plan so you can see the key milestones in that investigation. I sometimes see organisations handling investigations themselves, and those investigations can go on for quite a considerable amount of time. My preference is, depending on the nature of the investigation, that you look to conclude within a 3 to 4 week period. Sometimes not possible if it's particularly complicated, but you want to conclude matters without unreasonable delays. This might seem an onerous process, the planning process, but I have seen and had to remedy many poor investigations as a result of a failure to sufficiently plan for the investigation process. So I always say, deal with things proactively, follow a plan if you want to avoid having counterclaims or further grievances, or indeed constructive dismissal claims. So in terms of the grievance meeting itself, what I always advise is you invite an employee in writing to attend a grievance hearing and offer the right to be accompanied. My preference in terms of holding a grievance hearing is that I hold that after I've concluded my investigation. I might hold an initial investigation meeting with the employee. Once I've held my investigation meeting with the employee, I'll go about conducting my investigation. Once I've concluded my investigation, I've gathered my evidence, I've created a coded evidence bundle, I've as I say, analysed the output of the investigation. I then meet with the employee at a grievance hearing. I summarise the complaints they've raised. I talk to them about the grievance procedure, the investigation procedure I followed in relation to the grievance procedure. I then will ask the employee to comment on my specific findings. So I'll talk to them at the grievance hearing about my findings and ask them to comment on those findings and ask them if there's anything else I need to take into consideration, or do they believe there's something else I need to do as part of the investigation before reaching a final conclusion. The reason I do it that way is it gives the employee the opportunity to see early on the findings from my investigation and for them to add any other information they feel is relevant before I adjourn and then look to reach my overall conclusion relating to the complaints made. I always say thank an employee, and if they're accompanied, their rep, for attending the grievance meeting. Introduce any note taker and explain their role, or if you are recording the meeting, tell the employee you're doing so, never covertly record. If the employee is unaccompanied, ensure that they understand they have the right to be accompanied and ask them if they wish to reconsider their position on having a companion with them. You should always summarise the purpose of the meeting and provide a summary of the employee's grievance as you understand it at the outset of that grievance meeting. So we add context and we give a clear framework for the meeting itself. You should ask the employee if they have any questions. As I said, you should present the findings from your investigation, ask them to comment on them. Ask the employee any questions you may have for clarification to ensure that you're understanding things correctly. Summarise what's been discussed during the meeting and your understanding, and explain to the employee that you'll be adjourning to consider your findings from the investigation and the responses during the grievance meeting itself. And then you can confirm to them that you will either meet with them again at a reconvened hearing, or you say to them that you will set out the outcome to their grievance in writing. So that's important to consider. Again, we've touched on the right to be accompanied. Workers have a statutory right to be accompanied at grievance meetings, and we should look to comply. A companion can be a fellow worker, a trade union representative, or an official employed by a trade union. Sometimes I will vary that list and I will allow a family member to attend, for example, if the employees suggest to me that that may be a reasonable adjustment I could make to help them engage with the grievance procedure in a more meaningful way. So in terms of the outcome of the grievance procedure, following the meeting, you need to decide what action, if any, you're going to take. Decisions should be communicated to the employee in writing without unreasonable delay, and where appropriate, they should be set out. You should set out, what action you're going to take as the employer to resolve the grievance. The employee should be informed that they can appeal if they are not content with the action that's been taken or the outcome of the grievance procedure itself. After attending the grievance meeting and adjourning, I always advise working through the following checklist. I will send Joe a copy of the slide so you can have a copy of this. But my checklist always includes what was the original grievance about, so be clear on this and write it down. You want to take that into consideration when you're producing your outcome letter. Now that you've fully investigated the complaint, has the grievance been refined, altered in any way? And to be clear on this and write this down, you need to keep a clear record of your findings and your thought process, essentially, so that if you are challenged, you can refer back to what you did and why you did it. Make a list of all the evidence you've gathered which supports the grievance, Based on the information gathered from the investigation, is there a grievance to address? Remember, be analytical. So you need to analyse the output from your investigation and consider everything which is relevant. That should shape your findings. If the grievance is not well founded, you need to consider how you will explain this to the employee while still being supportive. Be clear on this and write down what you will say. So when you meet with them or you write to them, you can be really specific about why you have found in a certain way. If the grievance is well founded, you need to consider what will you do to address this. Typically, we see matters being referred to a disciplinary hearing. So it may be there will be a respondent, and due to their own conduct, you may refer the matter to a disciplinary hearing. Now, my preference when I'm chairing a grievance process is that once I've adjourned and I've given consideration to what my findings will be, and I've produced, essentially my outcome letter, I like to reconvene the grievance hearing, allow the employee to be accompanied by their companion, and I like to communicate in person the findings from my investigation from the grievance procedure so that I can speak to them in person and I can explain why I've reached the conclusions that I have. Now, I will say, remember to allow the complainant to be accompanied at the later meeting because it is still part of the grievance process. I consider it to be a reconvened grievance hearing. Always confirm the outcome of the grievance process in writing. I will caveat my approach where I hold a reconvened meeting. You don't necessarily have to do that. You can simply write to the employee to inform them of the outcome. My preference is to sit and meet with the employee because I often find I get a better outcome, and sometimes we avoid having having to go through an appeal process. Not that there's anything wrong with going through an appeal process. The employee has a right to appeal the outcome of their grievance if they're dissatisfied. But I often find it's helpful if you meet with somebody and you talk to them about your findings. Now, the outcome letter is an important document. I can't stress this enough, and it's one the employment tribunal will place the most weight on if a claim for constructive dismissal or discrimination is made. That letter should tell a story. When an employment judge is reading that letter, they should be able to see what the complaints were about, what you did, and what conclusions you reached. So it should be sufficiently detailed in nature, and it shouldn't be vague. It should be very specific and consistent, and you should respond to each allegation. When I write a grievance letter, sometimes my grievance outcome letters, if I'm chairing the overall process, will be very lengthy. I also produce an investigation outcome report as well, which summarises all my findings. So there's a lot of work that goes into doing the grievance process justice. Make sure the outcome letter is well written, as I've already said. It needs to be clear and concise, absolutely, as it's likely to be the subject of the most scrutiny during an employment tribunal if you indeed face a claim, not suggesting you will. And always offer the right to appeal at the end of the outcome letter. Really important. I know I spoke about that early on. So there concludes the webinar today. I appreciate it was a whistle-stop tour of handling a grievance process. I hope you found it useful, and I hope it gave you some tips and tricks that you can take away with you. I always say at the end of these sessions, we offer leading HR services at Frettons. If you've got issues and you need support with those issues, we provide support around HR case management, workplace investigations, mediation, and chairing formal hearings. Thank you very much for your time. I'm going to hand back to Joe, and we can go through questions.
Wow, that was quick, Nathan. I think that's the quickest you've ever done one.
It is. They're very efficient.
Have you got your contact details up that you can
Yes.
provide? Okay, cool.
There we go.
Right, there's a few questions. So Isla's put, once the grievance meetings have been held and the person who the grievance was against, what if they ignore or dismiss the grievance raised against them or disagree with all the points made against them?
And is this the respondent, Joe? Just so I'm clear, is this the
Yeah,
respondent? Yeah.
yeah.
I mean, look, ultimately, if you found that there is, that the grievances raised are supported by the evidence you've gathered, then you're going to need to make a decision about what you do to address those concerns with the respondent. So if we feel there's a case to answer, say the grievance concerns allegations of bullying, and you find there is evidence to support that the respondent has been bullying the complainant, then ultimately that matter is going to need to be referred to a disciplinary hearing. And it will be for the disciplinary officer to then make a decision about the outcome of that disciplinary process. And it could be that a sanction is imposed. So it could be a written warning, final written warning, or even dismissal. So ultimately, if the respondent, is dismissive of the findings from the grievance procedure, and they're not behaving in a way that instills confidence in you that they are going to, step back and reflect on their own conduct, then it may be you're going to have to take further steps with that individual to address your concerns. So I think it's you've got to play it by ear ultimately. But if a grievance is upheld, it's likely you're going to need to take action with the respondent. Would be my response. I hope that answers your question.
Um, Jerry's asked, in respect to the actual investigation meeting with the employee, the employee the grievance is against, how long in advance of the meeting should you provide the information to them in respect to the other evidence you've collated?
Is this in relation to a disciplinary hearing, Joe? Sorry.
Yes,
Yes.
in relation to the actual investigation meeting with the employee the grievance is against.
Oh, right. Well, in an investigation meeting, if I'm interviewing a respondent, I invite them to the meeting and I set out the matters being investigated, and I go through it during the meeting. I don't make available at the investigation stage copies of evidence. The only time I will look to make available any copies of evidence to a respondent is if it's been found that there's a case to answer, so the grievance is being upheld, and we're going to proceed to a disciplinary hearing, because that's the only time they're going to need the evidence that we're going to rely on at a disciplinary hearing. So before then, I don't do that. And the reason I don't do that is not to entrap anybody or to trip anybody up, but it can get in the way of a good investigation meeting, because if you make available to a respondent early on the evidence you've gathered, what you'll find is that person's going to come in probably very prepared with their responses, and you're going to give them additional thinking time. And actually, what I find is most compelling is to bring somebody into a meeting. I invite them to a meeting, I give them notice. You don't have to. An investigation meeting isn't a formal meeting, it's a fact-finding meeting. But I do give the employee notice. And what I then do is go into detail during that meeting, what the nature of the allegations, and then capture their responses in real time. And that can often be very telling. So my recommendation is you don't give copies of evidence or even copies of the grievance letter, for example, at an investigation meeting. There's no need to do so. But absolutely, what I would stress is if the respondent is being referred to a disciplinary hearing, in good time ahead of that hearing, you should make available all copies of evidence you're going to rely on and discuss during that disciplinary hearing, so that individual has sufficient time to prepare their case. I hope that answers that question.
Samantha's asked, why would the investigation come before the hearing, the grievance,
Yeah,
and what the issues are?
yeah, so you could, are you talking about the investigation meeting, sorry, Samantha, with the complainant?
Yeah, may I ask why the investigation would come before hearing the grievance and what the issues are?
Yeah, so my preference is that I go away, because if the employee submitted a letter in writing setting out the nature of their complaints, they confirmed to you that that letter contains all of the detail of their complaints. I go about investigating first to establish, what may or may not have taken place, and then at the grievance meeting, I can then meet with that individual and talk to them about their complaints and talk to them about my findings from my investigation and ask them to comment on those findings. I find it's really important and actually really helpful, particularly if you're going to be having to defend a claim later on. There's no guarantee of that, of course, but if you were, it is really helpful to be able to demonstrate that when you met with the employee at the grievance hearing and you discussed their complaints and you were able to talk to them about the findings from your investigation, and that employee could comment on those before you make any final decisions. So oftentimes I'll find that I've done a really good investigation and I'll say to the employee, actually, here's the findings from my investigation in relation to the complaints you made. Can you comment on them for me? What's your thoughts? And sometimes the individual has been able to say, actually, sorry, I didn't share this information with you. I think it's relevant. Could you take that into consideration when you are making decisions on your findings to my grievance? So that's why I do it that way. You could look to hold a grievance hearing at the front end with the employee and talk to them about their complaints. My preference is to do it the other way around. Ultimately, there's no issue. You're fully complying with the grievance procedure. They're having the opportunity, sorry, to attend a grievance hearing and for their grievance to be heard. So I hope that answers your question, Samantha.
Jeanette's asked, what recommendations do you have in dealing with an employee with special needs?
Well, if you're talking about special needs in relation to that having an impact on their ability to engage with the grievance procedure, I'm always really proactive. If someone says they have, it may be disabilities, for example, and that I need to consider making reasonable adjustments, I will always go as far as I can within reason to accommodate any request for reasonable adjustments so that that person can engage with the process meaningfully. I always adopt the approach of gold standard. I will go beyond what is, the bare minimum, if you will, because I want to be able to demonstrate that in all of the circumstances I've acted reasonably. So my response to that would be, if you've got someone that says, look, I've got some special needs, it may be in relation to a disability, I will always respond and say, thank you so much for sharing that with me. I really appreciate you sharing that information with me. What do you need from me so that I can help you engage in this process meaningfully? You set that out, and if I can accommodate, I will. And obviously, they've got to be reasonable, but I will often bend over backwards to try and accommodate, because for me, I want the individual who's raising complaints to get the most out of that grievance process.
Cool. So Joe's asked, am I right if the person the grievance is against is dismissed, but at the dismissal meeting raises a counterclaim, this has to be investigated regardless?
What if the respondent, sorry, Joe, is dismissed? Now,
So if the person the grievance is against is dismissed,
yes.
at the dismissal meeting
Yeah.
raises a counterclaim, it's got to be investigated regardless.
Well, I would always say if someone's being dismissed and they're then going to raise a counter claim or grievance, as you put it, is that an appeal? Because if that's an appeal, that often I see this and we'll go, actually, it's not so much a grievance, it's more an appeal against their dismissal, and then I'll treat it as an appeal. So I think that's a really important distinction to make. I think if you've got an employee who you have dismissed and they have raised grievances, now I would always say absolutely investigate those concerns, particularly if the concerns they're saying is connected to the company's decision to dismiss them. But if that were the case, that's more of an appeal than a grievance. So, and I would be more minded to treat it as an appeal. But you have to treat each case on its own merit. So it's a bit of a generic answer, but that would be my review, but my response, sorry. But yeah, ultimately, if someone's raising serious concerns, then you need to make a judgment on your investigating to establish facts around what has happened, particularly if that person is likely to bring a claim and you've just dismissed them. And this counter grievance, as you put it, is essentially in response to the grievance originally raised against them.
Okay. Jeanette's asked, what's your thoughts on mediation?
Always use mediation if you can. It's not always appropriate, but it can be enormously successful. I'm a trained mediator. It does require the consent of both parties. If you have one party that says, I'm not prepared to engage, we can't enforce that. And so we have to accept that we can't proceed. But it is worthwhile offering mediation and absolutely recording that you have made an offer of mediation.
Sorry, I'm just reading the next one, Nathan. So Georgina's said, we once found that the outcome was not strong enough to take down the disciplinary route, but we did make recommendations for the respondent, in brackets, to do some confidentiality training, and they didn't agree and wanted to appeal. We said no right of appeal, but they didn't want this outcome letter on their file. Was there anything else we should have done? We said they couldn't appeal as it wasn't their grievance, and as there was no formal action against them, there was nothing for them to appeal.
Yeah, absolutely correct. They weren't subject to any formal proceedings, therefore there is no right of appeal. Ultimately, if you found, following an investigation, that their conduct has fallen below the standards that you would expect, and the recommendation of that is that they should attend training, their refusal to attend training, in my view, could be regarded as a willful refusal to follow a reasonable management instruction. That in of itself could be regarded as potentially an act of gross misconduct and leave them liable to disciplinary action. And you would want to investigate that with them, albeit the investigation would be very straightforward. So, it's if the recommendation was that employee was to attend training and they've decide, no, I'm not doing that, and it's quite an unreasonable refusal, then I would recommend you treat that as a disciplinary issue and go through the disciplinary procedure. So, it's not for the employee to say, no, I'm not attending what we potentially would regard as mandatory training. If they were, they could raise grievance. They felt that, they were unhappy that they were being asked to go and attend this mandatory training. They could raise a complaint themselves, and you could consider that complaint as a separate issue. But ultimately, if you've asked them to attend training, it's during their working hours, it's funded by the organisation, there's no detriment to them. I see no reasonable reason why they should refuse. That would be my response.
Jeanette's asked, when would you suggest is an ideal time to get a private investigator involved?
If you feel that you haven't got any independent parties that can provide an independent investigation that's free from bias. So I always say, if you think that something's going to be contentious and that you haven't got the sufficient management structure or independence in terms of employees available to conduct the investigation, always outsource is my view. And I don't say that as somebody who sells kind of outsourced HR services. I say that purposefully because I've been in-house. I've been an in-house HR director, I've been an in-house HR manager, and I've dealt with many issues where I've said I'm outsourcing that because it's better to get somebody external, fresh pair of eyes, independent, and it means that I can defend any claim around the investigation being tainted essentially by bias. That's my response on that one.
Thank you. Would you believe we've actually no more questions at the moment?
Amazing.
What I'll do is I'll just do the clause, but in the meantime, if anyone does have any other questions, then we can come back to them if that's okay.
Yeah.
Okay. So, as I've put on the messages, we will send out some correspondence to everyone that's signed up for the event this afternoon, and I'll put a post again on LinkedIn. So, if you do want a copy of the slides or the recording, then please put a comment against the LinkedIn post. Our next event is on Thursday, the 12th of March, and is called Learning to Fail. A link for that will be included in the email this afternoon. If anyone's recruiting, we've also got accountancy recruit, FD recruit, exec recruit, and charity recruit within the group. But otherwise, if I'll see if there's any more questions in a minute. But otherwise, I'd just like to say a massive thanks to you, Nathan, for your time and effort in putting it together, and to everyone for tuning in.
Oh, you're very welcome. And to everyone that's joined today, thank you very much for your time. I appreciate it's over lunchtime, but I hope you found it useful. So thank you very much. I'll see you again soon.
We've got another question.
Yeah, go
Um, Isla's asked, if we have a fact-finding meeting with the respondent, do we have to let them know they can be accompanied for this fact-finding meeting, or is it only for the hearing?
Yeah, no, there's no right to be accompanied at an investigation meeting, only a formal meeting. The reason I would say, you may remember at the start of the webinar that I talked about, holding an investigation meeting with a complainant and then allowing them the right to be accompanied. The way I work is I always like to differentiate between the grievance hearing and an investigation meeting. If a complainant submits a letter and I have questions, and typically I do, I then say, look, I want to meet with you at an investigation meeting, and you have the right to be accompanied. And the reason I do that is because the ACAS Code does state that all meetings relating to a complainant's complaint, they have the right to be accompanied. So whilst typically an employee attending an investigation meeting doesn't have the right to be accompanied, if the employee has raised a grievance and that investigation meeting is related to their grievance, I treat it as an extension of the grievance hearing in sense and say you have the right to be accompanied. So I hope that answers that question.
Yeah, she's put brilliant. Thank you.
You're very welcome.
Right, thanks very much, Nathan. I'll see you again in a couple of months.
Yeah, thank you very much, Joe. Take care, everyone.
Right, see you later. Thank you.
Thanks. Bye.
Bye.